All right, thank you everyone for joining us this afternoon. Today we're going to be talking about the FTC's Notice of Proposed Rulemaking and the changes to the negative option rule and what it means for marketers. Today is going to be a shorter session than we normally have. Normally we do an hour on these types of things, but we really wanted to just hit the high points and talk about what the primary changes are and what they mean for you. I'm Shahin Rothermel, and I'm joined by my partner, Rothman. We are in Venable's advertising group. We advise clients and we litigate cases and resolve investigations involving the FTC, including on negative option issues. So let's jump right into it. Here's the overview of the proposed changes in the Notice of Proposed Rulemaking. The FTC has said that the purpose of the rule, the updated rule, will be to really standardize the guidelines and harmonize the requirements for advertisers and marketers in this area. What we're seeing, though, and we'll talk about today, is that the rule is really seeking to codify within a rule what the FTC has listed as its expectations in things like guidance, enforcement guides, settlement decrees with certain companies that are not binding overall on the industry. So what are those? First of all, the rule, the negative option rule, previously applied only to pre-notification plans. Those were things like book of the month. You would ship a CD or a book to customers, and unless they canceled and shipped them back, you would continue to charge them. The FTC is now broadening the rule so that it applies to any auto renewal continuity plan, what we normally think of negative options, which are free-to-pay conversions or free fee-to-pay conversions. But stated simply, it's any provision under which a consumer's silence or failure to take action is interpreted as acceptance or continuing acceptance of the offer. It's really not that narrow negative option category that it used to be. The rule heightens certain disclosure requirements, including the clear and conspicuous standards, setting forth specific elements. It's imposing very specific consent requirements. It's using this language, unambiguously affirmative consent. It's now mandating acceptable cancellation options. We're hearing a lot of buzz about this click to cancel rule. It's also imposing what we've been referring to as a mirror cancellation rule as well. And it limits the ability of companies to attempt to save the sale or save the customer, essentially hindering any type of retention effort that you would like to impose for people who are asking to cancel their auto renewal. What will happen if the proposed rulemaking goes into effect and is finalized is that it would allow the Federal Trade Commission to seek monetary penalties of the rule. Right now, inflation adjustment in 2023 is $50,120 per violation. It now creates what we previously saw was that the negative option rule imposed sort of specific issues surrounding the billing. What is a negative option? It's that billing, it's the transaction. What are you going to be billed and when? But now what the FTC is doing is it's actually imposing additional requirements for the underlying product or service. And so it's creating an independent violation for a general misrepresentation or a material omission that's unrelated to what we traditionally think of as the negative option offer itself. It's raised some questions with us about whether or not, for example, false or unsubstantiated claims for products sold on a negative option basis or failure to disclose material information would be things that the FTC would say, you violated this negative option rule, even though you've made misrepresentations or omissions that were unrelated to the negative option pricing itself. Ari and I recently handled a case that involved the FTC taking this very stance. However, now it would be codified, written down within a rule. The FTC is likely going to use this to target B2B service providers. We get this question all the time. Am I bound by the FTC's rules and regulations related to these items, to these requirements, when I only sell to businesses? I don't sell to consumers. We've seen this quite a bit in the payment processing space. So we anticipate that we'll continue to see the FTC using this to target B2B companies, even though the FTC's jurisdiction is very limited in that regard. And I suspect that if a company chose to challenge it, you might see a court maybe disagree with the FTC's position. Ari, do you want to talk about ROSCA?
Sure. So ROSCA has been around for a while. The FTC has been enforcing it. But what is new about this rule is it's going to codify what the FTC has been angling for over the last several years, which is what's bolded here. The rule would expand ROSCA's requirements and scope beyond negative option terms like pricing. So the typical ROSCA case would involve a situation where a marketer failed to clearly and conspicuously disclose all material terms really related to it's really related to the transaction, but to like pricing, and the term of the offer and sort of the things close to those issues. What this will do is go beyond that. So whereas the face of it says that you have to clearly and conspicuously disclose all material terms of the transaction before obtaining the consumer's billing information, what's really going to happen, and what the FTC has been angling for, including in a case that we settled recently, is any material term of the offer that has a negative option component, so unrelated to the billing information. For example, if you don't disclose a limitation on an efficacy claim about the product, that would be a violation if the rule is passed. It would be codified. The FTC is already trying to do that, but this would make it easier for the FTC to pursue that option. And then we have, so then that leads us into sort of like the four areas that this rule would really touch on. The clear and conspicuous disclosures, that's one, so we'll do that first. We've listed out here in these slides what needs to be disclosed in these specific slides. None of, just for completeness, none of this is particularly new. Like the consumers will be charged, what the recurring basis would be, how you have to cancel, the deadline, the amount of the charge. All the information here is just for completeness for sake of this slide. But if we go to the next one, this is new, the clear and conspicuous in terms of how to disclose it, the bold part. In any communication that's solely visual or solely audible, the disclosure must be made through the same means as the communication. That's, seems pretty straightforward. But this piece, if it's both visual and audible, like a TV ad, you have to present it both in visual and audible portions. So if you have a TV spot where you're putting the disclaimer somewhere in white lettering, or whatever the color lettering is, before the ad ends, you now have to say it. Now it has to be audible. So that's new. We've listed out the other ways that you can clearly conspicuously, the requirements are clearly conspicuously disclosing things. Again, these aren't new. It's here for completeness, but item number one, that is new. It is technical. It is something to take note of. I guess we could, so this is my two. So again, more of the normal requirements for clear conspicuous disclosures. Here, the new point is no hyperlinks. So even if you have a clear and conspicuous disclosure that says something like, click here for offer terms, or click here for negative, you'd even call it negative option terms using the legal phrasing, though nobody, might not, a lot of people might not know what that is. You still can't hyperlink anymore. It has to be on the page. And they expressly say that a disclosure is not clear and conspicuous if a consumer must take any action, such as clicking on a hyperlink or hovering over an icon to see it. So going back to some other webinars we've done, we've been using the words unavoidable. Here, it has to be unavoidable, but the actual substance has to be unavoidable. Can't have an unavoidable link. That won't work anymore for purposes of these negative option immaterial term disclosures. So where to disclose? This is kind of to take note of too here. If it's directly related to the negative option feature, immediately adjacent to the means of recording the consumer's consent for the negative option feature. So you have a click to action button, so sign here, or I agree, or whatever the button is, the checkbox, it has to be next to it in one way or another. You can't have it below, can't have it too far to the right, can't have it diagonal with a lot of space. It needs to be right there in one screen. If it's not directly related to the negative option features, that gets the efficacy example I gave a few minutes ago. The disclosures must appear before the consumers decide to buy. So They don't exactly say where it needs to be, but the idea is that all the material terms of the offer need to be disclosed, other than pricing, or in negative option terms. That needs to be next to the call to action button, but everything else needs to come before that. Still has to be clear and conspicuous, still has to be unavoidable. And if you're in an FTC enforcement action, we're going to want to be able to point to that when we're responding to a civil investigative demand, or the worst case scenario, a lawsuit. Then Shahin, I think you want to maybe talk
Sure,
about.
let's talk about consent. This is sort of a big one. The Restore Online Shoppers Confidence Act, which had been in place for many years since the Obama administration, requires that you obtain express informed consent to the negative option terms. But now the FTC has expanded that. They're using this phrase, unambiguously affirmative consent. The seller must obtain unambiguously affirmative consent to the negative option separately from any other portion of the transaction. And the seller must obtain unambiguously affirmative consent to the rest of the transaction. This is not new. The consent language must not include information that interferes with, contradicts, or otherwise undermines the consent that somebody's providing to the negative option transaction and the rest of the transaction. And they're saying that the consent request must be presented in a manner clear, unambiguous, free of any information not directly related to the consumer's acceptance of the negative option. We'll talk about this, but I really think that this is going to open a can of worms for advertisers, because what really is the consumer's acceptance of the negative option? I mean, we've got these specific terms, but the problems really arise because the FTC, as we talked about a little bit earlier in the slide, has enumerated a number of negative option terms. But here's the problem, is that we've talked in the past about California plaintiffs' attorneys who say that material terms of the transaction or material terms of that offer for California's auto renewal law includes other elements, things like the refund policy, the return policy. And so the FTC, while its stated goal here is to harmonize its requirements with state laws and provide more guidance under federal law, I really don't know that this is doing that. Because now as a seller, you have to think about how much do I have to disclose, what relates specifically to the negative option transaction versus the rest of the transaction. So that's almost going to be the first thing. And then when you are disclosing the negative option terms, making that disclosure effective, right? It can't be too long. It's got to be comprehensive enough. So, and it has to be made in a way that you don't have consumers getting disclosure fatigue. So now what the FTC is really doing is asking us to find that Goldilocks scenario, not too little, not too much, in terms of what you're disclosing. Now, as Ari mentioned, the negative option disclosures must appear immediately adjacent to the request for the consumer's consent to that negative option feature. The rule says that you'll be deemed in compliance if you obtain consent through a checkbox, signature, or other substantially similar method that the consumer must affirmatively select or sign to accept the negative option feature and no other portion of the transaction. So what you have here is what is essentially a safe harbor through a checkbox or signature, other type of method. Maybe that's a radio button, somebody free form typing their name. But it doesn't explicitly require a checkbox. So it really raises the questions about what does that mean? What else could I do? Is there a certain level of friction that I can introduce into the process that is obtaining people's consent to the negative option that's other than a checkbox? And my position would be that yes. We've talked in the past about a number of cases that have come out of California and state and federal courts regarding consent to other things like arbitration provisions and class action waivers, which are very important if you have online terms and conditions and you want to limit your exposure to nuisance class action lawsuits. And so in those cases, what the Ninth Circuit even has said is that terms can be enforceable, things where you have consumers literally waiving their rights to go to court and participate in a class action. Those are enforceable in scenarios where, for example, you have language like, by clicking submit, I agree to, and then it's hyperlinked terms and conditions. And I think that the FTC, by refraining from explicitly requiring a checkbox, is acknowledging that. And I think that the FTC knows that they cannot, within this rule, explicitly require a checkbox. Otherwise, you really will have tension with what courts require in other areas. Having said that, we know to date that a couple of things. That's what really the FTC says is good enough, and so it probably thinks that is maybe it's required in the FTC's head. We've seen this as well in the context of settlement decrees. The FTC settlement decrees, this almost tracks that language verbatim. We've seen it with the California District Attorney Task Force. It has this very similar language as well. So we know that this is what the FTC is going to say is a safe harbor are these mechanisms, provided that you have the appropriate disclosure immediately adjacent to them. But again, it's a safe harbor. And even in the preamble, the FTC said that they were going to allow marketers to have some freedom to explore other ways. So there is flexibility. So here really the question is, what's sufficiently separate from the rest of the transaction, and what is the rest of the transaction? If you have terms and conditions, if you have a return or refund policy, is that the rest of the transaction, or is that the negative option offer? So these are things that you're going to have to think about when you're creating any types of new disclosures, and you'll have to adopt a stance on that and be consistent in the way you present that, let's say on your website, on telephone calls with consumers. If you have an in-person auto renewal like a gym, then making sure that that's clear and that you're presenting those in a way that that are separate and that you appropriately distinguish what is separate and what is not. Let's talk next about another C, which is cancellation, the one-click cancellation rule, and also the mirror cancellation rule. We did not put this slide in bold. We've been bolding all the new things, but this slide, essentially all of this is new under the FTC's proposed changes. ROSCA currently says that you have to provide a simple cancellation mechanism. The proposed changes now say that the cancellation mechanism must be at least as easy as the enrollment mechanism and provided through the same medium that the customer used to enroll, meaning that same website or mobile app that consumers use to purchase and enroll in the subscription. So we really call this the mirror cancellation rule. We've seen a rule, California's recent amendments to its auto renewal law started inching this way. We've seen other state laws in smaller states that are starting to inch this way, providing mirror cancellation, but it's really broader in as much as they say, if it's online only, you have to be able to cancel online. The FTC has gone really one step further, saying it's got to be that same channel. After receiving the cancellation request, the seller must immediately cancel unless it obtains the consumer's unambiguously affirmative consent to receive a save prior to cancellation. And that consent only applies to the cancellation attempt in question and not to subsequent attempts. So what does immediate mean? In California, for example, you can ask somebody to authenticate their account before you actually effectuate their cancellation. So this rule has not made clear what is immediate. Presumably immediate means immediate, but I would say that immediate means that it's timely in as much as somebody doesn't have to wait. They don't need to get a call back. They don't need to take any other action. They don't send an email and somebody sends them an email back. They don't send an email, somebody directs them to a website. That's what I think the FTC is really getting at. One thing that the FTC says here is that you really can't attempt saves. So one thing that is interesting is whether or not, as a seller, you can introduce any type of friction into the cancellation process. For example, let's say you really want to understand why people are canceling. You don't want to introduce friction, but you want to understand so that you can incorporate that feedback and improve your product or service offering. So what is acceptable there? Are you allowed to ask questions? Maybe, but the FTC says that a hang-up or disconnection is presumed to be a cancellation. So if you have somebody who is seeking to cancel and you do any type of "are you sure" or check-in requests, what the FTC is saying is that the consumer could disengage during that save attempt by closing the browser or disconnecting the chat and availing themselves of that easy cancellation. So the FTC is really taking this to the extreme. You can see here is what the proposed rule defines as saves, which is really any retention effort to retain the offer, retain the customer. What the FTC is saying here with the cancellation is it's imposing this additional consent requirement where you have to actually ask somebody if they'll agree to a save. So somebody says, I want to cancel, and then you say, well, would you like to consider additional offers? That's an option, but that's not in lieu of your requirement to cancel and terminate that contract. So what we see, and we're really seeing this a lot in California in response to California's law as well, is we're seeing companies that are, instead of doing any type of retention efforts, they're really focusing on re-engagement and reactivation after a cancellation. And I've been talking to a lot of clients about how they're doing that, and I think that that's something that the FTC would be amenable to, and that there are ways to do that in accordance with these requirements. Ari, do you want to talk about renewal reminders for digital goods and services?
Yeah, and like the other set of slides, all of this is not bolded, but all of this is new. So if we go to the next one, and I think the first, once it comes up, the first one is going to be the most important. So for negative options that do not involve the automatic delivery of physical goods, so memberships, for example, like Shahin said, to a club or to a gym, the sellers must provide at least annual reminders identifying the product or service, the frequency, the amount of the charges, and the means to cancel. What does it mean? We're already getting questions on this. Like, what does annually mean? Does it mean the first of the year? Does it mean a year from when the consumer subscribed? Those are all issues that haven't been clearly defined, or maybe even defined at all yet. But that's a situation that should be able to be worked out. If you just every September 1st, if you do it every September 1st, and you're going to hit everybody up annually. So, but that's an issue that has come up, and there's been some logistical questions about how that would be implemented from an operational level from various of our clients. At a minimum, the reminders must be provided through the same medium. So email, if it's email, it has to be email. If it's phone, that the consumer used to enroll. And then for in-person sales, obviously you're not going to go door knocking, and so the seller must provide the reminder through the internet or by phone, in addition to the in-person method, if it's like a gym membership or something like that, used for the consent to the negative option feature. So it's kind of both in that circumstance, but it looks like there is a little bit more leeway. If we go to the next slide, in terms of the next steps, Shahin, I think we've even had some questions in the chat about how this is all could get implemented and when. We've seen a lot of questions on that too, but Shahin, do you want to cover that?
Of course, and with the caveat, of course, that we're only reading the tea leaves about what will happen ultimately. Let's talk about what's happening now. So the next steps are that the FTC will publish this Notice of Proposed Rulemaking, NPRM, in the Federal Register, and it will open for a comment period, a 60-day comment period. And stakeholders in the industry will have the opportunity to submit comments, and we've had a number of clients who've asked about how to submit comments and what those would look like. And what they look like, what the FTC is looking for is information concerning what is really consumer beneficial to consider for negative option programs. And what I would say is that probably the most beneficial information to submit to the FTC in this respect would be things like data, consumer perception surveys. I know, Ari, you and I had talked about this a lot over the past few years, litigating these types of issues, is engaging a consumer perception survey expert. The Federal Trade Commission actually had a report years ago where it had heat maps and various types of abandonment data and click-through data where it showed what people did and did not understand. I think that type of data would be very persuasive to submit to the FTC, to the extent that companies and stakeholders already have that evidence in mind or available to submit. The FTC, it will be a 60-day comment period. What the FTC will often do is extend that comment period. No guarantees, though. The FTC has not published this yet, so that clock has not started ticking yet. During and after the comment period, what will likely happen with what the FTC does when it has similar types of notices and changes to rules and guidelines, that the FTC will often have workshops. I would expect that we're going to see at least one workshop here where the FTC gets everybody in the room and talks about it. They have experts talking about the various issues. We'll probably see data analyzed within that room. And so then what could happen is that the rule could be modified from its currently proposed form, or it could be finalized in its current form. This probably will not occur for many months, simply because the FTC will need time to review and analyze the comments and take them into account. After that rule becomes finalized, there will be the potential for companies to challenge the FTC in litigation on the rule, saying, for example, that the basis is not sufficient to justify the changes in that rule. So what's going on right now is a lot of different things in the commission, I would say, though. I would say that, first of all, the FTC, this is happening simultaneously with a lot of different activity at the FTC. One thing that's really still hanging out there is that the FTC has issued its intent to update the disclosure guidance, the .com disclosures, that is quite a few years old. We talked a little bit ago about that idea that hyperlinks are no longer, information that is behind a hyperlink is no longer clear and conspicuous. The FTC has hinted in public statements that hyperlinks might not be sufficient under those .com guidelines, or might only be sufficient in a less limited sphere than they've currently permitted those to be used. So there's really a lot going on here. There's not going to be the rule won't be finalized for some time, but given these requirements, our recommendations really are to start thinking about them and start getting into compliance and seeing how you can do it, what those policies, what the website would look like. Ari, do you want to talk a little bit about that too?
Yeah, so on the next steps in terms of risk reduction, one of the things that's actually not on this bullet that I thought of that should be is monitor the timing of when this is going to go into effect, because all the slides leading up until this point are going to require operational changes. And those operational changes always take longer than everybody thinks they will. And what you don't want to do is get put in a situation where the rule goes into effect and you still haven't figured some of these issues out. We've seen that a lot in our practice. So start thinking about how you would adapt to these changes, and especially the ones that could be more complicated. Every, of course, business and client is different. The updating the user experience, and the disclosures, consent, cancellation processes, that's sort of hand in glove with what I was talking about. Sort of rank those and figure out which ones are going to be easier or more difficult for you to comply with, and get a health check on them too. Start testing them. I mean, those are things that if you are dependent largely on online sales of the type that we've been discussing in this presentation, you're going to have to start thinking about right now. When I said health check, that was really the second bullet. Conducting the compliance audit, test shopping for current offers, and those sorts of things. Make sure that the changes that you make are reflected in your terms and conditions, customer service policies, training manuals, and everything else. The second you make one change, it affects everything holistically. And in an again, worst case scenario, investigation, litigation, we're going to want to be able to show that you implemented these changes across the board and that the contemporaneous documents reflect that. Check the refund policy. And the last one is always true. Identify and reduce complaints. But if you're seeing a lot of complaints that pertain to the issue, and chargebacks too, that pertain to the issues that we've been discussing up until now's like sort of like a heightened time to get around that. Unclear, at least it's unclear to me whether Visa, how far behind Visa and MasterCard are in terms of these changes, but that's something that should also be monitored in real time. We literally have less than like 30 seconds until it's 2:30. So that's our presentation. Shahin, do you want to close it out?
Sure. So, I mean, we've thrown a lot at everybody. There have been a lot of cases in California, in particularly addressing these issues. I've gotten a lot of questions here in the chat about hyperlinks. So we'd be happy to talk about that after the fact, because I think there's a lot of cases that would address that. But if you have any questions, please contact us. We'll get to the questions in the chat and respond to those afterwards. But thank you, everyone, for attending. We really appreciate it, and have a good afternoon.